Hi, everyone. Harry here to discuss two important developments in the Judge Chutkan January 6th case, which seems to be going quickly to the possible release of the whole series of appendices that accompanied Jack Smith's 165-page brief. All right, first we have a response yesterday from Jack Smith to a motion by Trump to dismiss the whole case based on the Supreme Court's Fisher decision. I'll explain that in a moment. Then today, we just have a recently received motion by Trump to Chutkan asking her not to release the appendices as in redacted form, which redactions would be much more extensive than the ones in the brief itself, asking her to stay until after the election. Let's take them in turn. All right, the Fisher case. That's the case in which the Supreme Court narrowed the construction of, or as the special counsel has it, clarified the construction of a law, 1512C2, that is a substantive count in Trump's charges in the January 6th case, as well as a conspiracy count. And Chutkan ordered Trump to go ahead with the substantive motions to dismiss, even as she considered immunity. So he's done so and filed a scattershot motion, which somehow tries to take the Fisher case and argue for the entire indictment, including the two counts, the two substantive counts that have nothing to do with that law, and say it should all be dismissed. And he throws in a lot of stuff about immunity, as he does now in all his motions. But what Smith says is, first, there's nothing about the opinion in Fisher that gives him the ability to have a motion to dismiss. Indeed, the allegations remain, and remember, they did the superseding indictment, arguing specifically that he sought to create and use false evidence to obstruct the certification proceeding. The theory that even as reinterpreted by the Supreme Court, Trump's conduct still violates the statute because he's trying to impair the integrity of evidence. The paradigm might be shredding stuff or, balling it up and swallowing it, but that's not all that is needed. There are other ways to violate 1512, that statute, including by impairing the integrity of evidence. So that's one problem. The other problem is these are really arguments about the facts. The case hasn't been heard yet. It's not a basis to dismiss now at the outset without even having the facts presented. Maybe at the end of a trial you could try that. It has nothing to do with the other counts whatsoever, and is the attempt to put in the immunity stuff is really misplaced because there's a whole parallel proceeding going on now about immunity. So that's their pretty forceful response to Trump's separate motion to dismiss the whole indictment based on the Fisher case. Now, as to this morning. Kind of puzzling. Trump, recall, let that 165-page brief be published, and it has all kinds of bombshells in it, as people have pointed out, and he didn't try to immediately run to the Court of Appeals and get a stay to keep them from doing it. Now, the question is the appendices, and they are, we're told, voluminous, and I'm sure they are. This is basically the whole kit and caboodle, all the evidence in the case, grand jury transcripts, and the like. Now, there's a category of evidence that is sensitive information as defined in a special order. And the special counsel has said, unless it's already been made public, that stuff should stay redacted. So we haven't seen it, but the appendices have been filed with a lot of redactions. That's what the special counsel urges should now be published. So it won't be everything, but man, it'll be a lot. And Trump, again, rather than, he said he asked for 7 days so he could seek appellate remedies. She gave him 7 days. Those 7 days end today, Thursday, October 17th. And as far as the record reflects, as of now, he hasn't gone to the Court of Appeals and sought a stay. He's rather just asked Chutkan, pretty please, you have your own discretionary power to keep this from coming out. You have said that you're not going to be affected by the timing of the election and that Trump doesn't have any special rights there, but the people in the election are going to be deceived. They will get supposed one-sided evidence, whereas if it's released the same day that we respond to the brief, November 14th, 9 days after the election, then they won't be deceived. But it's really saying, take special account of the election and do something you wouldn't otherwise do, something that Chutkan has made clear she's really disinclined to do. And the basic motion of the special counsel is the way these things would normally be handled. You have a presumption of a public right to this stuff unless there are reasons not to. There were very limited reasons for the brief itself. Only the special counsel said where witnesses would be identified. There are broader reasons here and more that would be redacted, but otherwise that's it. And really Trump is just saying, pretty please use your discretion. Why is Trump not already run to the Court of Appeals to try to seek a stay? It's just not clear. And as of now, the table is set for Chutkan to simply say, denied. Here are the appendices in all their glory and kilograms for people to look at other than the redacted, non-public sensitive information. So as of now, unless he does something, I think we should expect it to come out and we'll have the same kind of diving expedition, but deeper, because we're talking about all kinds of stuff that will be in the appendices, even with redactions. So that ought to be happening one way or another. I think he either seeks a stay from the Court of Appeals and thereafter potentially from the whole court, the U.S. Supreme Court, and tries to at least stall through November 5th, or it comes out and pretty soon and we have a whole nother round of stories as people mine the nuggets from the appendices as they did from the brief when it came out. So stay tuned for that today, and I'll talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.